A couple of other housekeeping notes is if you're having any issues with the chat bar for asking questions, you can also send an email to Lisa Darko. So I'm going to go ahead and pass it over to Judge Fairgrieve. He's going to have a presentation on the screen, and we really appreciate you joining us this morning. Thank you, Judge Fairgrieve.
Well, thank you very much, Paige. Let's see, Lisa, if you could put up the PowerPoint. Good morning, everyone. I had a brief conversation last week with Lisa Darko and with Paige concerning doing a quick CLE this morning to talk about the orders both from the Supreme Court and our local orders that are governing what we're doing right now. And then talk a little bit about what's going on here in our court. Lisa, you can go to slide 2. Both in terms of criminal aspects right now and civil aspects, but then also talk about what our plans are for the future at this point. So let's turn to the next slide. All right, talking first of all about Supreme Court orders. I'm sure most of you have probably been on the Supreme Court's website, seen their orders there. If you haven't, if you go to their website and look on the right-hand column there, you'll see something you can highlight and click on orders. There are a whole set of their orders there. There have been a series of more generalized orders and then some special orders that deal with particular areas of the law. I'm going to be talking about their most recent special or general order. That's the one from April 29, 2020. So I think the highlights from a criminal perspective there are, first of all jury trials are suspended until at least July 6, 2020. I would emphasize at least July 6th. We haven't gotten any follow-up information from the Supreme Court yet, but I'm sure as we get closer to that date, we'll be getting some additional guidance. Non-jury trials can be conducted by remote means or in person with observance of social distancing and other public health measures. I would suggest there that certainly our last alternative really is to have people in the courthouse using remote distancing. It's difficult for us. And I'll get into that in a little while. So our goal really is to try to conduct hearings and non-jury trials by remote means if we can. Out of custody matters are going to be continued until June 1st, at least June 1st, 2020. Proceedings that can be conducted remotely and matters that require in-person attendance but should be heard immediately still have to strictly comply with social distancing and current health mandates. And then finally, arraignment on out-of-custody criminal and juvenile matters between March 18th and July 3rd may be deferred until 45 days after the filing of the charges. So let's go to the next slide. All right, so talking again about criminal matters, in-custody criminal and juvenile matters may be continued at this point with certain exceptions. And those are the cases we've already been doing: first appearances, arraignments, and change of plea and sentencing hearings. We've been doing those, almost since the beginning of this. Continuance of criminal matters is required at this point, and the Supreme Court has identified that from the date of its last order, April 29th to September 1st, is an excluded period. The judges sat down and took a look at that order and the previous orders that the Supreme Court had issued, and we've taken a position that that there's an excluded period from March 16th, 2020 until September 1st, 2020. And we're currently in the process of issuing scheduling orders at this point for those trials that fell between March 16th and now. And we're taking that excluded period into account in terms of setting new trial dates for those cases. Next slide. The Supreme Court's been very clear to us, indicating that the courts must allow telephonic or video appearances for all scheduled criminal and juvenile matters whenever possible. I'll talk about what is possible for us in a little bit. For hearings involving a critical state of the proceedings, the court shall provide a means for defendants to have the opportunity for private continued communication or discussion with their attorney. This has been one of probably our most difficult issues for a while, although we were able to have first appearances essentially right after the first order came down from the Supreme Court in about the middle of March. One issue that was a problem for us was trying to provide criminal defense attorneys with the ability to talk confidentially with their clients during hearings. We've solved that at this point. Actually, the recommendation came out of the jail of all places. There are 3 cell phones that the jail has in its video sort of pod area, and criminal defense attorneys can talk with their clients on that cell phone in a confidential way during hearings. So, we've been able to address that at this point. It's not a particularly elegant way of doing so, but it's working, and I think that's what we need to do. Next slide, please. All right, as far as civil provisions are concerned, civil jury trials are suspended in the same way that criminals are through July 6, 2020. Non-jury trials, again, can be conducted by remote means or, if necessary, in person using social distancing. Of course, our focus is going to be to try to do those remotely. Non-emergency civil matters may be continued until after June 1st. However, the courts should begin to hear non-emergency matters, again, using remote means or distancing. We're doing that now. I'll talk about that in a few minutes. And emergency civil matters are going to be given priority over others. Lisa, let's go to the next slide. So as far as turning to our orders, much like the Supreme Court, the Clark County Superior Court has issued a series of orders directly, after the Supreme Court did, often reflecting a lot of the information in those Supreme Court orders, but also reflecting what's going on here in our county. Our order specifically indicates that persons exhibiting symptoms of COVID-19 are not to enter the courthouse or other court facilities. Inside the courthouse, all persons present need to observe social distancing and be at least 6 feet from any other person. There are not too many people in a courthouse on a daily basis. I will tell you that down in G1, where we're actually doing our arraignments at this point, I think normally that courtroom can hold about 96. We've got it set up in the pews so that social distancing will be enforced. I think there's space for about 16 people in there right now. Masks are not required at this point. This is an ongoing discussion. I think at the Supreme Court levels, what I understand and hear locally, we haven't gotten any solid guidance from the Supreme Court on this particular issue. I'll tell you that one of the issues that is out there that we have to confront in terms of this is that there's this access to justice issue, in terms that if we're going to require individuals to wear some sort of a mask into the courthouse, if they don't have one, we're going to have to provide that for them. So we're working hard now at this point to try to put together a group of masks or set of masks that we can give individuals as they come into the courtroom or courthouse. Hopefully we'll have that available for them here in the short term. Our main concern in that regard is telling somebody, we can't necessarily tell somebody you can't come into the courthouse unless your face is covered, because it would deny them access to justice, and that's certainly something the Supreme Court in its orders has indicated we simply can't do. All criminal and civil jury trials are continued until at least July 6th. The matters that were scheduled, as I indicated earlier, between March 18th and July, since they're stricken, they're being rescheduled at this point. As I say, scheduling orders are going out this week. Delays in the time for trial are excluded periods under Criminal Rule 3.3 sub E8. Can we go on to the next slide? So beginning May 4th, or last week, criminal and civil or family law bench trials can be conducted via telephone, video, or other remote means. And in fact, we had one that took place earlier this week I'll talk about in a bit. Beginning also on that day, all in-custody criminal hearings shall be stricken until June 1st. The same exceptions that were talked about in the Supreme Court order apply here, and we've been doing those hearings. Also on May 4th, all out-of-custody matters are stricken until June 1st. Those exceptions for the same types of hearings are down below. And as I'll talk about in just a bit, we're actually beginning to hear some of those hearings, here now, and we will be doing that in the short term. Next slide, Lisa. Through June 1st, all family law matters will be special set with the assigned department. will be done by remote means or in strict social distancing. Family law trials shall go forward at the discretion of the assigned department by remote means or in person with strict social distancing. And also beginning on May 4th, all family law motion dockets are going to be scheduled using remote means or in person with strict social distancing and other public health measures. Next slide. So as kind of an overview here, beginning April 14th, all the dependency and termination matters have been addressed by another general order. If you haven't taken a look at that, it's pretty special, it's specialized, to address specifically dependency and termination matters. I'd suggest you go to the court, website, Superior or Supreme Court website, and you can pull up that order and take a look at it. Beginning March 18th, the UD docket is canceled until June 4th. I'll tell you that Judge Gregerson has been working with a number of stakeholders, within the sort of UD context, and they're beginning to address what things are going to look like. I think we're all mindful that there's going to be a substantial number of cases that are coming. Of course, we're affected at this point by the governor's proclamation, talking about UD cases, but we've got a plan for what's going to come. It's just a matter of time in terms of when. Beginning March 23rd, the ex parte docket remains open. At this point, anybody who's used it knows that you have to submit your documents at this point, and whichever judicial officer is assigned to that is dealing with those matters ex parte and without anybody else present. So that seems to have been running pretty smoothly. We've been doing that since shortly after the middle of March. Beginning May 4th, settlement conferences are going to proceed using remote means. That could be telephonic. It's probably going to be Zoom in most cases, and I'll talk about that shortly. And then beginning March 23rd, all civil protection matters are governed by another kind of specialized general order by the Supreme Court. And again, I'd invite you to take a look at their website for that. Next slide, please. Our therapeutic specialty courts are continuing at this point based on procedures that each of the courts has adopted or each of the teams has adopted. And the courthouse remains open. On a daily basis, we have people coming into the courthouse. There are not a lot of them. It's not uncommon to walk through the courthouse at this point and not run into anybody. But right around 8:45 in the morning, there are now often people downstairs on the ground floor and up here on the 4th floor near Department 8, which is where we're holding the first appearances. Next slide. So as far as our current operations, in the criminal context, we are doing first appearances every morning. We're doing those in Department 8 right now. Currently, we have, as far as our ability to do cases and have, video contact with the jail, we only have 2 courtrooms that have the hardware to be able to do that. That's G1 in Department 8. We are doing the first appearances up in Department 8 right now because it's a smaller courtroom, and we are using a larger courtroom, G1, to do the arraignments because we have a larger number of people who come in or coming in for arraignments every morning now. We want to put them in a bigger space, to maintain social distancing. We're doing separate arraignment dockets on Tuesday through Friday morning. Historically, we would have those arraignments on a morning docket, kind of a mixture of a criminal docket and first appearance. We simply can't do that for 2 reasons. One, it's taking us about twice as long to do each individual matter as it did historically, just based on our, the transport issues in the jail in terms of just getting individuals down into their cubicles and back out for video arraignments, and other matters, first appearances. But also just the process of processing paperwork and getting it from the court, basically scanning it and sending it over to the jail for signature by the defense just takes a long time. And so, that's what's impeding us. We wouldn't be able to do both the arraignments and the first appearances and get done with them in any reasonable time in the morning. So we've had to split those dockets. There are also social distancing concerns that apply there. We're doing in-custody change of plea dockets every afternoon. We do those down in G1. The only thing I would mention about that is that originally we thought there was going to be a lot of demand for those. As it turns out, there hasn't been all that great a demand. We have the ability to do 6 on each docket each afternoon. We probably are doing about a half that number on an average afternoon. So So we have that capability. In terms of out of custody change plea dockets, we're planning on beginning those relatively soon. The issue there was fingerprinting, and although fingerprinting, of course, took place over in a jail for in custody individuals, there's this whole issue of social distancing and fingerprinting for out of custody defendants. And I had some discussions or exchanged emails with the clerk's office yesterday. They've indicated that their clerks are going to do that while wearing appropriate PPE or protective equipment. So we're going to be starting to do that here relatively soon, perhaps as early as next week. And so we'll have the opportunity or ability to do that. Although I understand from talking to representatives of the defense bar, there might not be all that much demand in the short term for out of custody changes of plea. And then finally, we can do limited special set criminal motions using remote means. We have been doing those. I did a number of those Friday. I know some of the other judges are doing those. I would mention to you that although we're gaining additional capability from the court perspective to do those types of hearings, I think ultimately where we may run into issues is just the jail's ability to support more of those types of hearings. Let's go to the next slide. Turning to civil issues, special set civil hearings are being done through remote means. We're doing more of those, frankly, with each passing day. Civil dockets are beginning starting this Friday. I think there are at least 3 or 4 departments that have civil dockets. Those are smaller than normal. They're all going to be done, using remote means. At this point, we're using WebEx, which is a video conferencing platform. We're not using it for that purpose because we have some problems with interoperability here. We're using it principally to support, video or telephonic, conference calls. Family law dockets are beginning this week as well. In fact, I know Judge Gregerson has one this Friday. I had a discussion with him yesterday and with a judicial assistant. We're requesting if you have a docket coming up or you need to get an item on the docket, you should talk with a judicial assistant. I know what they're doing is setting up these dockets so that particular cases get called at certain, particular times. So definitely, contact the assigned judicial assistant if you have a matter set on a docket currently, or if you want to have a matter set on the docket to determine how they're going to run that. Family law hearings are being done through remote means. And earlier this week, Judge Vanderwood did a Zoom-supported family law trial. I'll talk about that in just a moment. Next slide, please. So in terms of what our plans for the future are, starting with a planning assumption, I know that all of us would like to get back to a situation or something that is near normal for us. I think the reality is, and I think having talked with the other judges, that's not a very realistic approach at this point. It appears that social distancing is going to continue for the foreseeable future, and that we have to adopt those processes and procedures that we can to allow us to do as much as we can in terms of court hearings and the things we need to do using remote means, and to really minimize the necessity of individuals coming into the courthouse. Because whenever anybody comes into the courthouse, it increases their risk. There's more contact with other individuals, and it increases their risk, but also the risk for everybody who's in the courthouse here in terms of courthouse staff. So maximum focus is going to be on remote hearings. Our goal is to try to achieve as much capability as we can to do remote hearings using the Zoom platform. We knew early on within the first week or so that we were going to need to focus on remote hearings. We initially tried to use 2 platforms that the county had licenses with already. That would be the WebEx platform, and after that, Microsoft Teams. Unfortunately, WebEx just doesn't have the functionality to do the video conference hearings that we need to do. And WebEx as well doesn't have the functionality. So unfortunately, we spent a fair amount of time trying to make those systems work, and we were unsuccessful in that. We did know that other jurisdictions were running on Zoom. We were in a position where really we had to see if that software that the county had already paid for, if we could make it work, and it simply didn't. So now we've gone to Zoom. Zoom's being used by a number of large jurisdictions, including the state of Texas, the state of New Jersey, and also Pierce County. District Court took the lead in terms of Zoom because they have more administrative personnel. They've been running Zoom hearings this week. The feedback's been very positive. They're happy with it. and we'll be, we've had some Zoom hearings already. I think you're going to see with each passing week, we're going to be doing more and more hearings supported by Zoom. Our goal is to train our courthouse staff in a bar and Zoom supported court hearings. And as we all become more proficient at them, increase the volume of them coming through the system. Additionally, we need to increase the number of courtrooms that can do Zoom supported hearings. At this point, as all of you or many of you are aware, we use a system called JAVS to record court hearings. And we need certain hardware in order to make JAVS work with Zoom so that we can record the Zoom hearings through the JAVS system. Right now, we have that hardware in G1 and Department 8. But we don't have that hardware in the rest of the courtrooms. So we're really constrained by that. Ms. Gurley, our court administrator, told me this morning in the email that we're looking at 2 to 3 weeks before we get the hardware to convert all of our courtrooms or to enable all of the rest of our courtrooms. So for the next 2 to 3 weeks, we're going to be constrained to G1 and Department 8. But we'll use that time to be able to, or to begin to train everybody up, expand use of our Zoom hearings. And by the time we're able to go, hopefully everybody will be relatively familiar with the Zoom system. Next slide, please. So in terms of planning for jury trials, as I indicated earlier, no jury trials before July 6, 2020. And there's an excluded period in criminal cases up through September 1st, 2020. Judge Collier is serving on a statewide committee that is working to develop jury trial protocols. We hope to have some initial guidance by mid-June. I will tell you that I think we anticipate the process is going to be difficult and time-consuming. I'm not sure how realistic it is at this point to think that we're going to have a first jury trial on July 6th. We've been working and thinking about conducting jury trials in a socially distanced environment for some period of time. Judge Collier, in fact, was working earlier this week looking for locations to hold at least the voir dire aspects of those hearings offsite at a larger area. This is going to be a very challenging issue for all of us. And we know it's time sensitive. We know there are lots of criminal defendants who've been waiting in jail or waiting for their trials. We'd like to offer them the opportunity to have their trials as soon as possible. But we have to do so in a way that's consistent with public health recommendations. And that's our goal. One thing I wanted to say about Zoom is that Judge Vanderwood had a Zoom trial in family law this week. One of the two parties was an unrepresented party. It went, as I understand it, pretty well. The reason, or one of the reasons it did go well, is that the parties were fairly cooperative as far as discovery and cooperative in terms of the exhibits themselves, agreeing which exhibits would probably be admitted, and focusing whatever objections they had to certain exhibits, which Judge Vanderwood was able to rule on. They were then able to put together an exhibit book or log and be able to use that at trial. I think there's an opportunity to use Zoom for bench trials. However, I think that in order for that to happen, the parties have to be relatively cooperative and have to be able to agree in many regards in terms of which exhibits are probably going to be admissible or not admissible, and get rulings on those that they disagree on before trial. So long as that's the case, I think that there's an opportunity to do trials using Zoom and using exhibits that are admitted and filed with the clerk. We're working at this point for some alternative means, including perhaps the use of a software such as Dropbox to support Zoom trials. However, I'd say that's a little ways out. Once we all become more familiar with the Zoom platform, I think we'll have an opportunity to try some hearings and then move toward more trials using the Zoom platform as we become more comfortable with it. All right, next slide, Lisa. All right, at this time, I'm happy to answer any questions that you have. So Lisa, I'm not seeing anything up on my screen in terms of any questions. Oh, there we go. All right. All right, I have a question. It says, some of the processes we're using, let's see. The question is, some of the processes we are using in the probate group submitting non-contested matters electronically are working, and we'd like to keep these processes once the pandemic has subsided. We're planning on submitting these to the court administration. Is that a proper way to get these to the right person? The answer is yes. In fact, for what it's worth, there's been some conversation among the judges about what we've been doing in the probate context and also in the guardianship context. I think some of the procedures we're using now are working well, and I think there's some positive feeling about adopting some of those procedures as more regular procedures as we go forward. Next question, do we need to use a particular version of Zoom, and are there ways we can start getting competent on Zoom now? As far as the particular version, I think everybody can use the regular free version of Zoom in terms of being a participant in a particular Zoom hearing. If you're going to be hosting hearings such as what we're doing or what the bar is doing today, there's a higher level license that gives you more functionality. If you're going to be involved in that for one reason or another, or hosting Zoom sort of meetings or CLEs or conferences, that sort of thing, you probably need to get a higher level license so you have more functionality. But I think otherwise you're fine. As far as ways of getting competent on Zoom, I think if you get online and do a search, using Zoom for courtroom or that sort of thing, there are a number of items that will pop up. There are on YouTube a number of training videos, on Zoom. So I think there are a lot of opportunities there. Tomorrow, there's a district court CLE. I think that's going to address some training for Zoom. I understand district court also provided some training to attorneys who appear in front of it regularly. Last week, we're going to be using a lot of that same information, I think, and pushing that out to attorneys that we see in Superior Court on a regular basis. All right, I have a note that says no additional questions at this time. What I'd like to do is take this opportunity to thank all the members of the bar. I know that this is a difficult time for everybody. In retrospect, perhaps Superior Court should have been a bit more active in terms of communicating with the bar. I think it's our intent to do so in the future. One thing we've been dealing with is the same sort of uncertainty that I think attorneys have been dealing with. We were waiting on a regular basis for more information coming from the Supreme Court. At this point, I'm not sure how much more is going to come to us. I'm sure there's going to be some, but I want to thank you for your hard work. Many attorneys have shown a lot of flexibility in terms of participating in telephonic hearings, more recently Zoom hearings, and I appreciate your working to help your clients in this difficult time and cooperating with the Superior Court and the clerk's office to do what we need to do. Our goal is really to try to provide as much service as we can, as quickly as we can, given the sort of public health concerns we have. So thank you very much for participating today.
And thank you, Judge Fairgrieve, for being available.